Hi, my name's Dan Fowler. I'm president of the Apartment Owners Association. We're one of the largest individually organized group of apartment owners in the state. And we're real happy to bring to you this webinar. We've got a couple great speakers for you, get a lot of information. Our goal, of course, is that you find or discover at least one idea that'll help you make and or keep more money than ever before, or make the management of your apartment buildings easier and more profitable and more enjoyable. We'll also get some financial ideas for you as to what to do with your apartment building financially with estate planning. There's a couple, we've been getting a lot of emails from our members, and I'd like to make you aware of a couple of them. One of them, these people came from the Soviet Union over here, and they said, let's see, my wife and I retired. I'm nearing 70 years old. And this June, my wife's going to be 67. We're both immigrants, refugees from the former Soviet Union, moved to the USA on its 200th anniversary, 1976. My wife and I each put in more than 40 years of work in this country, paying for the pensions of the previous city mayors and current city councilmen and women and governors and people of this nature. We managed saving some money to purchase an older 14-unit apartment building, hopes to provide some security for our older years. The state of California is looking more and more like the country that we came from, which is the Soviet Union. Total disrespect to private property and entrepreneurship, and the politicians are mostly on lookout for votes neglecting the principles of capitalism, free enterprise, respect for private property. Here is a scene from our tenants. Some of them, not all, feel that they have the legal right not to pay. Unfortunately, that is definitely not so. Why would they pay? They just move on after a long eviction process with a lot of months, if not years, of free rent. So why should they pay now? Well, I can tell you why they should not pay now, and that's because the politicians are basically alluding to the fact that they can't be evicted, so they don't have to pay. That's a good reason. Finally, the city leaders are lawless and shameless and fearless, as they are the creators and rulers of this new post-common sense thinking. Hopefully, justice will prevail if it exists anymore. Another person, a lady, she has a house. She's partially disabled. She's working for Oakland. The tenant is working for the Oakland Unified School District and still getting paid. And she's not, however, paying the rent because of the virus. But she's not only that, she's not trying to pay anything. Trying to make a deal for maybe half the rent? No, she's not going to pay anything. She won't return a call. She won't pay. She's a bad actor. Meanwhile, I can't pay the mortgage or anything. There's another apartment owner in trouble. Why? Not because of a virus. It's because of the reaction to this virus that these people are in trouble. It's because of the politicians who want to buy votes out there that these people are in trouble. Now here's another lady. She has a solution to the problem. And here's her solution. She owns rentals from Kern County to Solano County here in California. 3 houses, 2 duplexes, and 4 fourplexes. Total of 17 units. In great big capital letters, she writes, I am listing my Oakland fourplex to invest out of state because the government has forced me to keep unwanted tenants and to also put it to me for my income. No thanks to the virus and our tenant welfare government, I expect my property to lose value as a result. And I'll skip quite a part. It was quite a long email. And down below, she's talking, she wrote, oh, by the way, folks, and if you would do what she did, when I learned about AB 285 I sent an email to all 80 Assembly members to urge them to vote no. Now, if each of you listening out there would do what this lady did and send a letter, she sent an email to 80 council members and tell them how bad this stuff is, they might start listening once in a while. Folks, all you have to do these things, and do this if you'll follow this lady's example, and I think we can do better out there. We're all in this together, right? That's the biggest lie I've heard, folks. We're all in this together. Are you really in this together with the politicians who have taken your income away from you? Are you really in this together with the tenant group that is formed that says we want free rent, we're not going to pay the rent, we're going on a rent strike? Are you really all together? Are we all together in this? I'll tell you who you're together with. You're together with other property owners. You're together with those tenants who want to go back to work. That's what you're together with. We're not all in this together. You know, they say if you repeat a lie enough times over and over and over, that people will start believing it. There are some people out here watching me right now who believe that. And you've said that. We're all in this together. Sure. Sure we are. They're against us. They're against you. And they're in the process of taking your property away from you. She continued, Mr. Bonta, who is an assemblyman, would you want to go into debt or deplete your savings because your employer, which in this case is the state, or source of your income, is not paying you, but they continue to get an income, and you can't quit your job? You're tied in. You can't go someplace else, Mr. Assemblyman. You know, I think she's got a pretty good idea there about stopping the pay of all the congressmen and all the politicians, every last one of them, especially the mayor and the governor of the state, stopping their income while this lockdown is in effect. Maybe they would feel like the people are. Maybe they'd feel like the 27-year-old who has 3 kids and can't put food on the table. Maybe they'd feel a little bit like him. In addition to that, we need cash. Another thing is that they're doing is that we need cash, not a note in 10 years. And that's a position we take. They're talking about giving you a note and collecting it 10 years. How can you possibly pay your mortgage? How can you possibly pay all your bills? How can you possibly live on a note? Oh, they say, but you can sell the note. Yeah, at half price. How can you live with those kind of income from your rents and rentals that you have that are there? We're looking for something, and you guys can help me today. We're looking for another plaintiff. As you know, we're in the process of doing a lawsuit against the Judicial Council, which has basically closed the court down for evictions. And in the process, we need the best plaintiff that we can find. We're still looking. We have some very good ones, but we're still looking some. And let me give you some requirements, because some of you may qualify for this if you'd like to help out. You got to live in a place where there isn't a local moratorium or rent eviction. In other words, the only thing that's standing between you and eviction is the courts being closed down, this Judicial Council rule that they've come across. Judicial, they're legislating laws. And you have a non-paying tenant, and you'd like to evict that tenant. If you can meet those requirements, you own a building in an area like that, you have a tenant who's not paying, and you'd like to do it. And best, of course, would be a small-scale tenant, but the bigger ones, if we need to go with that, we can go with that. As you know, Pacific Legal Foundation is in the process of filing it. We'll send a letter out next week and show you the letter that they wrote to the Judicial Council challenging the legality of what they're doing, letting them know that, hey, this is not constitutional. So we're going to be doing that, and look for your email to get a copy of that. But if you meet those requirements that we have there that I've given to you, and some of the cities that do do have the first requirements, Banning, Beaumont, Blythe, Calamasa, Canyon Lake, City of Coachella, Indian Wells, Lake Elsinore, Marietta, Norco, Palm Desert, San Jacinto, Temecula, are places where if you own a rental property there, have somebody that's not paying, you'd like to evict them, please email me, Dan Fowler, F-A-L-L-E-R, Dan Fowler, at AOAUSA.com. That's Dan Fowler at AOAUSA.com. If you have a building that fits that description, you have a tenant that's not paying there. Another thing, they're on your AOA website. If you scroll down just a little bit, you'll see where there's a petition. Click on that, sign that petition. We have over 86,000 signatures on that petition. We'd like to hit 100, so if you'll go on there and sign that, we would appreciate that. Another thing, we have two things coming up on the November ballot. One is to split the property taxes. In other words, split the properties off, split commercial property off, make commercial property pay taxes at any rate, which would be double, triple what you're paying now in all probability. For some of you, it'll be even more than that, but that's going to be on the ballot, along with another statewide rent control, which will take away, and just one characteristic of it, is going to take away vacancy decontrol. You will not be able to move, in most cases, your rents to the market when somebody moves out, if that petition passes. It's just like number 10 was 2 years ago. This is 10 number 2, only it's a little worse than the other one that we had. It's going to take a lot of money to do that. You say, I knew this was coming. Yes, it is. It's going to take a lot of money to beat these things, and if you want to beat them, folks, send your donations in, make your donations out to the AOA Political Action Committee. We will be fighting this for you. We also will need money for the lawsuit. We need to give money to the Pacific Legal Foundation, who's handling the lawsuit that's taking place, and that we're hoping that we will win and put this eviction nonsense to bed. I want to thank you for listening in today, and I want to turn over the induction. We've got some great speakers coming up. I want to turn over the introduction of those speakers to Jeff Fowler. Jeff, it's all yours.
Well, good morning, everybody, and we're just about to get started. And as you've heard, there are two different events, or two different speakers for today. And the first one is a leading eviction attorney, and he already has anticipated your questions. And so hold your questions till the end, but you will be able to ask questions. Hold those a little bit, and he'll probably answer it for you. And the second speaker is also just a tremendous leader in the area of estate planning. And this is also a good time to listen to him, and you'll learn how you can save a lot of money. And anyway, so that's all coming up, and we're glad that you're with us. When you do want to ask questions, the way that you do it is there on our website. At the bottom right, you will see a little blue box. And so in that blue box, you can just type away your question, and they'll be able to get back to you. And I did also want to correct Dan's email address. It's dan@aoausa.com. And he said Dan Fowler at aoausa.com, so that's not it. But just remember that when you want to email him, and you are the ideal plaintiff that we're looking for this, for what we're doing against the Judicial Council. So thank you so much. And this week it was really interesting. AOA's been around for a long time, and we have even second generation members. And I was talking to one of these guys this week, and just casually it came up that our tenant screening, it's not just something where you can call in, but it's done online. So they've been doing it for years and years, calling in every time, but actually you could even just get it 24 hours a day online. And so that was kind of funny. So it made me think that I should share that just so that we have a call center and we have that. And this time, specifically because fraud is so high, I just want to mention another story that I heard this week where they ran the credit check, but they didn't check the previous history of the address history. And if they had done that, they would have seen beyond the credit score and gotten a little more behavior. And so I just want to really encourage you, when you are running these applicants and screening your tenants, please be thorough. And I know in Berkeley, you can no longer, as of the 25th, you can no longer run the criminal report. But for the rest of you, that criminal report that we have has that address list so that you can go back and do due diligence on your applicants. Just really strongly encourage you, especially now, because fraud is way higher. And for those of you in Berkeley and other places, our double whammy, we call it, that eviction search does contain tax liens and civil judgments and bankruptcies. So you do get a lot of information on that. So use those services. And so also I just want to give a plug for our membership. And one of the things that you get with our membership is a magazine every month. But one thing that I want to tell you about the magazine is that lots of times on the back cover, we have this thing called the Money Savers. And so our goal, AOA, is to save you money and help you make more money. And so this is one way. These contractors and vendors, all of them are people that want to do business with you. They're open for business, or they wouldn't be advertising. So they're there and they're ready to serve you. So I want to mention that. And of course, the membership, it carries the magazine. Even more important, and just as important, we have the landlord-tenant law advising that we do. We have the forms, like the special form that's needed for Berkeley and possibly in the future for others. This is the application form so that you don't give consent. Anyway, it's new, and you'll want to use it if you're in Berkeley. So there's all the forms that we use, and those things, they are pro-landlord. They are for you like no other, and you will want to use those. The other thing we have is a special apartment insurance. We also have a resident utility, a RUB system for resident utility billing. And all these are great services. And one that I want to highlight, though, is the debt collection service. It's a debt reporting and collecting service. And right now, you can still hold your tenants accountable. And honestly, you owe that to the industry. If somebody hasn't paid, at least let the next guy know. And so, let the next guy know that, hey, this guy, he's a deadbeat. You got to let him know. So please do that. Report your debtors. And if it's a COVID-related debt, you can't report it yet, but all the ones from before, report them so that they're on file. We report it to the big three, so TransUnion, Experian, Equifax, they all get it. So report them, and if they want to clear their credit up, they'll come back to you and pay that bill. And so that's what we've seen happen. And anyway, that's just and the final benefit for the membership is that after this is done, this live stream, we're doing it free for everyone. But when this is over, if you want to go back and review, this is accessible. It will be accessible for members only within the membership area that we have. So please be aware of that. Sign up for AOA if you haven't. And now I'll get to the introductions of our first speaker. Our first speaker today is really a leader, one of the leading, he's the owner and founder of one of the leading eviction firms in Southern California, and just an incredible, tremendous man of integrity above anything else. And they specialize in evictions and the landlord-tenant litigation. And he is not only an attorney, but he is a landlord himself. So he's very involved, very active in this world. He sits on the board of directors at various apartment associations. Also, he sits on multiple legislative committees where he reviews and interprets proposed legislation affecting the rental housing industry. This is a high-caliber guy. Please welcome Mike Brennan of Brennan Law Firm.
Thank you, Jeff. All right, good morning, everybody. Thank you for tuning in. It's a little strange to be sitting here talking to 3 cameras and 3 people, so I'll do my best. It's usually we have a room full of people here. I'm here to talk today. We have a slide presentation. I'll start off with that. Due to some technical difficulties, we weren't able to put the slide presentation up on the live webinar, but before I get into the presentation, I'm going to give you an email address, and if you'd like a copy of the presentation, I'm happy to email it to you. So you can send a request for the presentation to question@mbrennanlaw.com. So it's question@m, like Michael, Brennan, BRENNAN, law, LAW.com. Having said that, we're going to jump right into this. If you would have been able to see the presentation, you'd see that it's titled The Landlord's Guide to Navigating Tenant Relationships During the COVID-19 Pandemic. And what I did was, over the last couple months, the bulk of what I've been able to do, because of the fact that obviously there's court closures and we haven't been doing evictions, the bulk of what I do is sit and talk with people on the telephone and read the ordinances. And the questions that come up on the phone tend to fall into one of several categories. And so what I did was I basically created these categories, and I'm going to go through and I'm going to address the most common questions that have come up. I will start with a little bit of timeline because it lends a backdrop to the categories, and it gives, I know most people know it, but there are some people that don't fully understand the timeline and what took place, so we'll start off with that. An overview of the situation. We have March 4th, Gavin Newsom declared a state of emergency in California. That proclamation of state of emergency is indefinite. There is no expiration date on it. There is no indication that there's an expiration date. Shortly after that, on March 13th, Trump declared a national state of emergency. On March 16th, many of the municipalities, like the city of Los Angeles County, they started to issue their stay-at-home orders based on the state of emergency. Also on March 16th, Gavin Newsom issued his first executive order, which was N-28-20. And that executive order, and this is important to understand, the executive order lifted prohibitions against the municipalities to enact their own somewhat, let's call it eviction moratoriums. So normally these municipalities would not be able to enact an eviction moratorium because they're prohibited by law. That executive order by Gavin Newsom lifted those prohibitions and allowed them to do that. The municipality reactions are, we all know what they are. The eviction moratoriums affecting residential and commercial tenancies emerged. Los Angeles took, from what I can see, the most aggressive anti-landlord approach. And as I said, for the last several months, all I've done is reviewed ordinances and changed ordinances and proposed changed ordinances, many of which were coming out of Los Angeles. The court's reaction to all of this was they immediately issued an emergency court holiday, which expired on April 17th, 2020. They also had social distancing closures through June 22nd, 2020, and that will become very important. I'm going to talk to you. In Los Angeles County, for example, presiding judge Kevin Brazile wrote a 10-page letter that came out on April 21st. And I'm going to summarize the letter for you so your expectations as far as evictions and when the courts will be opening and things of that nature, you'll understand how to temper your expectations. And then finally, as Dan mentioned and Jeff mentioned, the Judicial Council's reaction to all of this was to actually create law, which they are not able to do under the Constitution of California. And they issued an emergency rule. So what the Judicial Council does is they issue the rules for the courts, what the courts do, how they do it. They issued an emergency rule ceasing the issuance of all summonses for unlawful detainer for a period of 90 days past the expiration of California's state of emergency. So that's why that March 4th state of emergency becomes important, because it's important to understand that with no expiration date on that proclamation of state of emergency and the Judicial Council's response to cease this issuance of summons for 90 days past an expiration, which is indefinite, we currently have no idea when the courts will start issuing any of the summonses on evictions. And what that really means for the members of AOA is we have no idea when you're going to really be able to, you can file your evictions currently, but when will you be able to actually prosecute the evictions? In other words, when will those evictions be served on the tenants, and how much time will they have to respond? And obviously that becomes important because one of the questions I get all the time is, hey, should I be filing an eviction? And I'll go into detail on that in a second. But again, the Judicial Council issued that emergency rule saying no court in California can issue a summons on an eviction until 90 days after the expiration of the state of emergency. There is one exception for that. That exception is you can petition the court, and the court can determine if a summons should issue in a situation where what would typically be called in the industry a nuisance eviction. That would be a situation that is immediately threatening the health and safety of either other tenants on the property or the management or the property itself. So for example, if you've got an arsonist on your property who's lighting fires on the property, you could petition the court to have that tenant evicted under a nuisance statute, and the court would decide whether that rises to a level high enough to warrant issuing the summons. So right now it's untested. I haven't heard of a single summons that's been issued on that, but my firm, and I would suspect other firms as well, have already drafted the motions and the petitions, and we are moving forward with submitting those petitions to the court. We haven't heard anything yet. Hopefully we'll hear something soon. But again, we'll talk about another common question that comes up is anybody doing anything about these illegal laws? Yes, they are, and we'll talk about that in a minute. So what are the current state of affairs? Well, as you can imagine, I poll my clients every month, and April rents collected were between 80 and 90%. So that's not bad at all. Of course, that was the first month that the stay-at-home orders really kicked in. May rents started to slow down. Many of my clients saw 65 to 75% of collected rents and started receiving notices from the tenant that they had no intention to pay the rent, but we did see the rent collections drop. I'm expecting June to drop even further. And as I mentioned before, once these orders were issued, currently our state of affairs is that all these municipalities came out and created this confusing patchwork of ordinances. Some were more strict than others. We have what I would call a real power play taking place right now. We have I'll use Los Angeles because I'm in Los Angeles, but I'll use that as an example. The county of Los Angeles is trying to issue a power play where they say, even if a city, an incorporated city, has their own ordinance, if it is not as restrictive as the counties, then the county is the ordinance to follow. And last I checked, that has not been passed, but they are trying to get that through. So it's a real power struggle as to whose ordinance is going to control. And for members who own properties in multiple jurisdictions or multiple cities, it becomes incredibly confusing understanding, well, what are my rights? Very little. What are the tenants' rights? Quite a bit. What notice am I supposed to give the tenants, if any? What notice is the tenant supposed to give me, if any? What document requirements am I allowed to ask for? Am I allowed to talk to the tenants about evictions or paying their rent? So it becomes this incredibly confusing patchwork of ordinances, and very difficult to navigate through and really remember it. And for the first time in my career, I'll be talking to people on the phone and I'll say, I'm going to have to look that up before I give an answer because they vary all over the place and it's hard to understand. So one of my recommendations right off the bat is for any city you own a property in, go to the city manager's website or the city attorney's website and find the location of their current ordinance and read it thoroughly. That'll give you your best understanding. And I understand they're difficult to read, and some of them are very poorly drafted, which makes it worse. It makes it an interpretation issue. But if you have a specific question, even if it's a city that I typically don't function in, let's say Northern California, I would be happy if you wanted to email me the ordinance itself. I'd be happy to give you some sort of an interpretation on it. Also, I would encourage you to email me. I have a list, and we update it every single week. I have a list with the website and the links for all of the major cities in or I should say most of the major cities and counties in California. So you could just click on that link and it will take you right to the ordinance. And like I said, we update that every week because they change all the time. Also, as part of the current state of affairs, Governor Newsom announced 4 stages of reopening California. I believe we're in the 2nd stage now. It's interesting because Governor Newsom has been at odds with some of the municipalities. I think he's moved a little faster in reopening, and he set, I would call them looser guidelines as far as reopening than many of the municipalities. Los Angeles, again, for example. Mayor Garcetti indicates Los Angeles will open slower than the rest of the state. And these gentlemen are doing these press conferences almost on a daily basis. I noticed Governor Newsom hasn't been on in the last couple days. Very interesting to see where we're going to go with him being away and why he's been away for a couple days. As I said before, currently, under the best circumstances, let's assume that Governor Newsom rolled back the state of emergency on May 31st on the same date his executive orders are currently set to expire. As I said, that is not the date in there. There is no date, but let's assume that were the best case scenario and he expired the state of emergency at that point. Even under that, you would not be able to file an eviction until September 1st at the very earliest because of that judicial council rule. So again, we'll go into that in greater detail soon. The courts will not be reopening as they were before for an extended period of time, and that's the 10-page letter from Brazili that I think, while he was talking about the Los Angeles Superior Court, once you hear his statements, you'll realize that this is probably true for all the courts throughout the state. We've got AB 828, which will be voted on at a later date. It was supposed to be voted on earlier. That is the assembly bill that is suggesting that any tenant who can't pay rent during the COVID period could file a declaration with the court if they were being evicted, and the court would unilaterally have the decision to reduce their current rent by 25% and give them a year to pay everything back. So obviously that's being opposed by every landlord and real estate group out there. It would significantly reduce the value of your property because of the cash flow implications. So, and again, we'll talk about what various people and organizations are doing to fight this stuff later on. And then we'll talk about the possible lawsuit against the Judicial Council. It's not actually a possible lawsuit. Several organizations, Dan said he's going to put that letter out next week. I have a copy of the letter. I worked with somebody who has some real good inroads to the Pacific Legal Foundation. We were successful at getting them to finally take on the case. They wrote a letter to the Judicial Council implying that if they did not rescind their illegal rules, that a lawsuit would be coming. And they are very serious about that. So we'll talk about that as well. So that's our current state of affairs. Now let's talk about notice versus documentation of hardship requirements. One of the questions that comes up all the time is, I'm confused. The executive order by Newsom said the tenants have to give me notice. I have municipalities writing ordinances that say they don't have to give me notice. They don't have to give me documentation. So I'm going to unpack that for you because there's two different words that are being used right now. In California, under Newsom's executive order, tenants are required to present the landlords with written notice of their inability to pay due to COVID, either in advance of or within 7 days of their obligation to pay rent. So they are required to actually give you the notice. And I know there's a lot of tenants out there that aren't giving the notice and they've just ceased communicating whatsoever. But even under the California executive order, there is no requirement that the tenant actually gives you documentation. So now that gets us down to the municipalities. So what are the municipalities requiring? So again, it's a huge patchwork of different ordinances. Some are actually, they don't require anything. There is an important distinction between the word notice and documentation. Notice is simply the tenant telling you, I am unable to pay my rent due to COVID. And all of a sudden they fall within the protection of all of these ordinances. Documentation, on the other hand, is once the tenant gives you that notice and I say, for example, okay, give me documentation. I want a letter from your employer saying you lost your job. I want to see your expenses for the child care that you've had to take on as a result of COVID. Most municipalities are leaving that requirement out of their ordinances. So it is not that the municipality is saying they do not have to provide it. They are just absolutely silent on it. And by being silent on it, it does not create an obligation on the part of the tenant to give you that documentation. In fact, the city of Los Angeles put out a specific form that the property owners are required to use, and it actually implies that the tenants are not, that their ordinance actually says that they're not required to give that documentation, which is absolutely untrue. It's a misrepresentation. The ordinance is silent on it, like I said. So with the patchwork of the ordinances, again, you're going to have to read the ordinance and see if your local municipality prohibits you from demanding or requiring the documentation. Some don't. And most of them, if not all of them, are absolutely silent on it. So if your jurisdiction is silent on it, when your tenant notifies you that they can't pay the rent, then I would feel comfortable telling you then immediately write a letter and ask them for the documentation. It does not mean that they're going to provide it, and you may not be able to do anything about it if they don't provide it. But you want to start documenting all of what I would call your good faith efforts to interact with the tenants, to keep the building functioning properly, to keep the cash flow coming into the building properly. You want to document everything so that when the day comes, you end up in court, you have the ability to show that we acted in good faith, we asked for reasonable requests, we asked for documentations. And what you're doing by doing that is painting the picture that it was the tenant, by their refusal to provide any of the documentation, that was acting unreasonably. And most, if not all, of these ordinances specifically state that the tenant is able to raise COVID as an affirmative defense in an eviction. So even though they may not be required to provide you the documentation right now, they are going to have that documentation in the future if they're being evicted for rent, non-payment of rent that occurred during the COVID crisis. Because if they raise that as an affirmative defense, they will have to prove that in court. Now, there's a lot of judge discretion. What will constitute, evidence and the weight of evidence and how the judges will look at that will vary across the board. It'll vary by courtroom, to be honest. But the letter asking them to at least provide it to you, if not to save that documentation for any eviction that might come up, will go a long way in court to establishing that you acted reasonably, you weren't out maliciously harassing anybody, you were just trying to get the documentation to demonstrate that they were permitted to seek the benefits of any moratorium that might exist. So like I said before, the notice requirements for California are they are required to give you notice. There's no documentation requirements. For Los Angeles, let's talk about real quick what notice the landlords are required to give. Many of the municipalities have developed their own notices that must be served, notifying all of the tenants of the protections that the moratorium ordinance is providing for them. Los Angeles, for example, is you have to provide that notice to every tenant on a specified form that you are not allowed to alter or modify in any way, and for a period of 12 months after the state of emergency, or for 12 months after the expiration of the moratorium, every time you serve the tenant a notice, you will also have to give them that form with a notice of all of their protections. So that's Los Angeles. Santa Monica did the same thing. Santa Monica's ordinance, for example, was very specific. They actually built into it a what I'll call a tenant harassment provision that gives rise to a cause of action against landlords. The city of Los Angeles did the same thing. So again, you're going to have to read your local ordinance and see if these causes of action and these affirmative defenses are provided for. I do want to talk about the causes of action because they're very important for the landlords to understand. If, for example, Los Angeles, if the ordinance has in there a tenant's cause of action against the landlord, what that means is if you violate the moratorium or the requirements of the moratorium, then the tenant can actually bring an affirmative lawsuit against you as a landlord and sue you for a violation of the ordinance. And so that's a big deal. In Los Angeles, that's up to $15,000 per violation. And so you can imagine how that would be used as leverage in an eviction to get you to drop that eviction, is to say, well, look, we'll waive our $15,000 cause of action against you. So most landlords I know can see where this is going. If there's an ordinance that provides that cause of action, you file your eviction after all the moratoriums expire. That will be used, if not as leverage in the already complicated eviction process, but it will, the lawsuit will be filed simultaneously with you serving them the eviction, again, as leverage. So again, I can't repeat this enough. Wherever your building is located, find your local ordinance, read it, and if you have questions, like I said, call my office. I'm happy to walk through it with you. Let's talk now about court closures and reopening dates. That's the biggest question I get is, hey, when are the courts going to reopen? I get specific questions like, hey, if the courts are allowing to set trials for 60 days, my trial's already been in there, why aren't they setting trials, etc. I'm going to walk through all of that. So, as I said before, the courts went on holiday through April 17th. Now that's expired. What does that mean? No notice could expire no notice can expire by California law on a court holiday. Additionally, if a tenant was supposed to file an answer and that answer date expires on a court holiday, it's extended until the next business day. So the court basically set up a holiday starting back in March that went through April 17th. Essentially, no notice could expire until April 18th, which I think was a Saturday, so it would have been the 19th and 20th. No notice could expire till the 20th, and no default could be taken until the 20th. Now, they came back later and changed all that. Most of the Judicial Council said no default can be taken again. Same time frame as the 90 days after the expiration of the state of emergency, et cetera. So right now we are in no man's land. We are in limbo with the courts, and short of filing, which I'll talk about shortly, short of filing, there's not much you can do with an eviction right now. Now let's talk about Judge Brazile's letter about the reopening of the courts. And again, Judge Brazile is what we call the presiding judge in Los Angeles County. Los Angeles County has the largest litigation court system in the nation. And so they are a great example of what will happen all around the state. So Judge Brazile, again, 10-page letter explaining that the courts will not be reopening on June 22nd the way people think they are. He called this a managed delay. And the reason for the managed delay, as he expressed it, is the courts need to function, but the judges, the clerks, the bailiffs, they all need to be protected. And so they will continue to enforce social distancing. They need to set the courtrooms up in a manner that allows for social distancing. Jury trials, jury pools, witnesses, attorneys, parties, they will all need to be addressed in a manner that allows for the social distancing. And so he gave a rough timeline in the letter. This is not in the letter. This actually came from a clerk of the court who has given me inside information that's been very accurate, and given this information to other attorneys that I'm aware of as well. What is scheduled right now is for June 22nd, when the court opens at that date, then they will start to hear motions, and it will be motions only. So if you had an eviction that was already on the calendar, let's say back in April, you had a trial set, that has been continued for a period of not less than 60 days. So let's say it was April 17th. It was a Friday. June 17th would be the absolute first date, but the court's closed, so they're going to continue it again. And what my office has experienced is the courts are using multiple methods to notify us of the continuances, or in some cases, they've actually vacated the trial date entirely and have not given us a new trial date. They just sent us a notice saying these trials are vacated. We will notify you when they're continued. Those continuances that are coming up for motions that were already calendared prior to COVID, we are getting continuance dates of late August. So when the court says they're going to open up June 22nd for motions, yes, they are, but it doesn't mean that those motions are going to be heard right away. I'm starting to get the motions for late August. Now, on July 22nd, the court is supposed to reopen for non-jury trials. I do not anticipate that happening. This is just the information that they are discussing in the court. So it's June 22nd for motions, July 22nd for non-jury trials, and then they are scheduled to reopen August 22nd for jury trials. Now keep in mind, all those dates I just gave you were for all the cases that existed prior to COVID. So what are we talking about here? If we're talking about the cases that existed prior to COVID, realistically, you're not going to get those cases back on track until mid to late summer. And ideally, you've got your summons issuance date of roughly September 1st, assuming Gavin Newsom states that the state of emergency expires on May 31st, which I don't see any reason to believe he's going to take that state of emergency down. Not at this point anyway. So the question becomes, is there going to be a backlog? You bet you. There is definitely a backlog. With the moratoriums, though, where they said, for example, many jurisdictions said they don't have to pay it back for 6 months. Los Angeles said a year. Many are trying to go to a year. What they did was they flattened the curve, so to speak. It's a more common colloquialism. They flattened the curve of the backlog. So if that rent that's due during the COVID crisis doesn't have to be paid back for a year, then they're pushing all of these evictions out for any of the rent that was unpaid during the crisis. Does that mean that it's going to work and flatten out the backlog of cases? Absolutely not, because you still have all those cases that were on the docket prior to COVID that will need to be worked through, and they will be worked through very slowly. The courts are going to limit the number of people that can be in court at any time. So there won't be a flood of non-payment cases right away because of the moratoriums. But there will still be the backlog. There have been questions asked to me regularly, should I file an eviction right now? And there's different theories on this. And what I would tell you is that is an internal decision that you're going to have to make. I'm going to give you both sides of the coin on this. So let's start with, yes, you should file now. Why do I say that? Okay. I actually think you should start strategizing your evictions right now. I think with the moratorium starting to expire, now's the time to start figuring out, okay, what can I evict for? How am I going to set this up? How am I going to document it? And start thinking about it now. When you file any case, you're going to get a case number. So what I anticipate happening is right around August 15th, you're going to see landlords starting to just flood the court system with new eviction cases being filed. At that stage, you're going to really get a backlog. The pros of filing now are that you will get a case number that is lower than anybody filing after you. And those cases have to be heard first. So in other words, the lower your case number, the court has to hear your case prior to a case that's filed after you, which sounds great. But realistically, right now, very few people are filing evictions. I think in the last several months, we've probably filed maybe 15 on nuisance charges alone. No non-payment of rent, no unauthorized occupants, no breaches of covenant. So by waiting, are you going to get behind this backlog of people? Not very many people. So yes, you'll get a lower case number. You will be heard first. But the number of cases being filed right now is so minimal that it really makes no difference. Now, what are the downsides to filing now? Well, the downsides to filing now or relatively soon are, as soon as you file that case, by law, you are now prohibited from accepting rent. So if you do accept rent, the case that you filed is now dead in the water. You've spent all the money on attorney's fees. You've spent all the money on court costs. So is it worth it? Because what happens if you file now and you start, it certainly does open the door for discussions. If you file now, the court is still going to send a notice to the tenant saying your landlord has filed an eviction against you. That opens the door for discussions. But unfortunately, I don't believe those discussions will be very fruitful because you have people like Mayor Garcetti getting on the news and telling people, oh, you don't have to give your landlord documents, you don't have to do this, you don't have to do that, you don't have to pay your rent. So I think the opening the door will be very limited value. Not only that, what if your tenant does start working again? And a lot of tenants are really good quality people, and they don't like the fact that they haven't been able to pay their rent. They want to get back to paying rent. But you filed your eviction. So now you have a choice to make. If I take rent from them, my eviction's done. I lost that money. It may not be a big deal to you. Typical residential eviction to get it started is a flat fee, roughly $750 to $1,000. So you might think that filing the eviction to generate some leverage and open the door to discussions is the way to go, and you're willing to lose that $750 to $1,000. That's why I said it's an internal decision you will have to make. But I know a lot of my clients are mom and pops. They cannot afford to spend $750 on the eviction and then not take rent for the prolonged period of time that's going to occur because, again, once these courts reopen, there's going to be a backlog of the pre-existing cases that will need to be worked through. So realistically, what is the time frame I see you having to wait if you file now? You're going to have to wait about 6 months. So you might need to have the economic wherewithal to go without rent for a period of 6 months before anything substantive happens in your case. And like I said, I know a lot of my clients, they can't go 6 months. They will lose their property, especially mom and pops with single family homes. So will there be a backlog? Absolutely. Should you file your eviction right now? It's a decision you're going to have to make internally. Those are the pros and cons of filing it or waiting. All right, the next question, well, I just went through that. Should I file an eviction? We talked about the non-payment of rent. When did the rent become due? Let's talk about that real quick. If the rent became due before March 4th, which is the proclamation of state of emergency, you are permitted to file that eviction right now, and you would be, the tenant would be outside of the protections of the eviction moratoriums. So I would encourage you, if that rent or the utilities that they weren't paying or anything else on their lease or rental agreement that requires a payment, if those funds became delinquent prior to March 4th, I would encourage you to start thinking about getting ready to file on that case right now so you do get the lower case number. Breach of covenant, no, I wouldn't suggest you do anything on that right now. If you've got a real serious breach of covenant, call my office or call whatever eviction attorney you use, discuss the facts with them. You can't, by waiting, there, in most leases, especially if you use AOA's lease, which is an incredibly well-drafted lease, you will have a provision in that lease that's called a non-waiver provision. What it basically says is, if the tenant breaches the lease, and I don't do anything about it right now, that doesn't mean I've waived my right to do something about it later. I still have a legal right to file an eviction later, even if I've accepted rent. So like I said, most leases have that provision in there. So right now with all the moratoriums, you cannot evict people for any reason right now. I wouldn't worry about filing on a breach of covenant right now. The nuisance and the criminal activity, those are the cases that the Judicial Council has said we will issue we will decide whether we will issue a summons on those. Again, you're going to have to fill out your complaint and declaration indicating all the facts surrounding the health and safety concern that's risen as a result of the activity, and the Judicial Council will have to make a determination. Now, so when asking yourself, okay, my tenant's creating a nuisance on my property, so what is the degree of the danger to others? I'll give you a couple different examples. If your tenant is having multiple parties, loud, obnoxious parties right now, and it's upsetting your other tenants, is that a health and safety issue to the other tenants? It might be, it might not be. If they are violating some of the stay-at-home orders and having parties of 50, 60 people over, yeah, I would argue that that is. And I would argue that that's the kind of petition you should file right now to end that. What about if they're having Zoom meeting parties and it's loud, obnoxious music, but nobody's really present? I would suggest that a court is not going to issue any sort of a summons on that type of a nuisance activity right now. What about criminal activity? Again, it'll depend on what is the criminal activity. Is your tenant on the property drunk and falling down? I don't think that the court's going to put somebody out for that. I don't think they'll issue a summons on that. What about if this is a real story, what about if your tenant took a screwdriver and stabbed your manager in the arm with it? Yeah, that's the kind of case you should consider filing immediately, because that is obviously an immediate threat to the health and safety of other people on the property. That's the kind of case I'd be confident that the Judicial Council or the court will issue the summons on that. Are there other strategies right now that you should be giving consideration to other than evictions? There are. There are several strategies that my office has developed. I would be happy to talk to you about those, but I'm not going to do it on camera, and I'll be very candid about why. I am very well aware of the fact that the tenants' rights organizations attend these type of seminars. They go to trade shows. They always are trying to figure out what our game plan is and what we are doing. And what they do is, if, for example, I were at a seminar and I said something that came off to a tenants' rights organization as anti-tenant, they would immediately take what I said, blow it out of proportion, take it to the city leaders, and the city leaders, especially in Los Angeles, would use that misrepresentation to create a new law which prevents landlords from doing that. So I'm very hesitant to talk about strategies in any sort of a public forum. If you'd like to talk about strategies, what we can do is you would call my office, you'd set up a 1-hour consultation. I'm going to be honest with you, I charge for that. It's a minimum of an hour. So if you go half an hour, you might as well talk to me for the other 30 minutes about anything else you want to talk about. There is a fee for it, but again, I'm not going to discuss the strategies. They exist. They are effective. They are within the law, but as I said, right now is not the time to address them. Let me just make sure I didn't skip anything here. All right, tenant unions and rent strikes. I get this question a lot as well. I've heard many people call me saying, hey, Mike, I've got somebody on my property who's organizing a rent strike. And I know May 2nd, a lot of these rent strikes were supposed to go into effect. There's an organization, for example, called the LA Tenants Union. They're a strong organization. I would encourage landlords to remain calm about this. Do not go out onto the property and start engaging in any sort of adversarial conversation with the representatives of these unions. I will tell you right now, tenants do have a right to form a tenants union. They have a legal right. It is a recognized right. You're not going to be able to stop them from forming the union. However, there are things you can do. First is stay calm. You realize that your behavior is being scrutinized in the industry and in the state. Landlords get a bad reputation for things that are oftentimes not true. However, there are some landlords that have also engaged in unreasonable behavior, and that, again, everything we do is being scrutinized, and it is taken to Sacramento and used as a basis to create anti-landlord laws. So again, remain calm. Talk to both the tenants union, your tenants rather, and the tenants union representative. If you can get pictures or video of the tenants union rep talking to your tenants, that would be fantastic. I will caution you that you should suspect that you are also being videoed, so be careful about that. I've seen many times where tenants, my clients send me the videos. Tenants stand in their window with their phone on, videotaping things. So again, you stay calm, stay professional, stay polite, because you are probably being videoed by some tenant somewhere. But I want you to try to get the either a card or a name or a badge, the credentials for these tenant representatives. We'll talk about why in a second. I want you to keep diligent and accurate records of the representatives' names and your payments that you've received, your rent payments. Now, why am I saying keep these records of these people? In my opinion, there's two legal strategies that can be used against these, and you should start with a letter from an attorney to these organizations. So let's take the LA Tenants Union, for example. While the tenants are allowed to form a union, there is a cause of action called interference with contract. And it's my interpretation that by the tenants union reps coming onto your property, they are allowed to organize people, but they are not allowed to tell your tenants, don't pay the rent, engage in a rent strike. That's interference with contract. That would be a hefty lawsuit to file against the LA Tenants Union, or any tenants union, for example. So that's why I said videotape them. When you get the demand letter, which they typically send out, saying, hey, you're going to waive this rent, or we're going to go on rent strike, they've interfered with your contract, your existing contract. So a letter to them, a nice, nasty letter to them stating, hey, stay off the property, or we do intend to sue you. We know you're organizing a rent strike, which is interference with contract. That goes a long way in getting them to stop doing things like that. Additionally, we've run into people, and I've counseled clients to discuss this rationally with the tenants union rep. If they are advising your tenants on the laws in California, what they're doing is practicing law without a license. And that would be another potential legal strategy to use against them. That would be a bar complaint. So there are strategies you can take. If you'd like to talk more about them and how to implement them, I'm happy to do that. Let's talk about vacancies and tenant screening. I had a specific question come in today right now. Should I accept cosigners? Absolutely accept cosigners. I don't typically say absolutely under any circumstance, but there's a big concern right now that people, the question is, should I lease right now? I'm afraid somebody's going to get in there and then not pay the rent and use COVID. Very legitimate concern. So if you were accepting cosigners right now, you would never list a cosigner in the eviction, but you would have a cause of action against the cosigner if the tenant got in and didn't have the ability to pay you or withheld the money. So, you know, one of the things you should be asking right now in your tenant screening, if you decide that you are going to lease, is I'd like to talk to your existing landlord, and you would want to call that landlord and talk to them and say, hey, did they notify you that they're unable to pay because of COVID? You might ask for additional documents. You might ask for bank statements to show what's coming in and going out of their bank account right now. And as Jeff alluded to earlier, he actually stated it, AOA has a fantastic program where they can report credit. And what I'm going to encourage to all landlords in the industry right now is that we start a new trend. We should start reporting good credit, good tenant payments to the credit reporting agencies. And we should start reporting non-payment to the credit reporting agencies. Why am I saying start a new trend? Well, as many of you know, in 2017, all evictions became sealed. So you end up, the whole industry is ending up renting to people that have been evicted multiple times, and nobody knows it. But guess what? If the landlords start reporting credit for good and bad rent payments, guess what shows up on their credit report? Good and bad rent payments. The eviction might not show up, but you will see, hey, they were using Rose Management Company. I just made that up. And look, they've got 6 months of non-payment at Rose Management Company. So it's an effective workaround for the evictions, the sealed eviction records. But I'll be the first one to tell you, I'm not a credit reporting company. AOA can help you out better with as far as what are the criteria to report that. They can give you guidance on that. I would certainly encourage you guys to start doing it. And then finally, small claims actions. Are we able to file small claims actions? I would encourage you not to file a small claims action on any rent that accrued during the COVID period. There's potential downside to that. First of all, under a moratorium, take a city, for example, that said any rent that wasn't paid during COVID, the tenant has a 6-month window now to pay it back after the moratorium expires. Technically, what they've done by creating that moratorium is that they have moved the due date out 6 months. So if you file your small claims action now, the argument can be made that that rent's not even due and you could lose the case. And if you lose the case, there's a limited precedent that would be set. And if you go to evict at a later date for that same non-payment, you might find yourself in trouble because you might find the court saying, well, you already got a judgment, that rent wasn't due. So that could be a problem for you. Now, I will say, again, there's more to the small claims. I think it is an effective strategy if done correctly, but that's the kind of thing that I would encourage you to call my office, set up an appointment, and we can talk about how to use that as a strategy. All right, general liability. A lot of clients are asking me, hey, do I have liability? What if a tenant gets sick? So you have no obligation, you have no existing duty to keep your property free of COVID. So if a tenant claims that they got COVID from your property, that's going to be a tough lawsuit for them to succeed at. Let me explain why. It's important to keep what an attorney would call the burden of proof. Keep that in mind. If a tenant claims that they got COVID from your property, they have to prove that you owed them a duty to prevent the COVID. And COVID is invisible. You cannot prevent COVID. It's like saying, it's very similar to saying, well, I got the flu from your property. You're going to have to prove that at court. So don't worry about that. And then they're going to have to prove that they contracted COVID as a result of some duty you breached to clean the area. So I wouldn't worry too much about the general liability. But one question that came up is, am I required to tell other tenants if one of my existing tenants came down with COVID? Right now, I'm unaware of any obligation you would have to tell it. In fact, it'd be an invasion of privacy issue. But again, it'd be the same thing. If your tenant gets the flu, are you required to tell all your other tenants that they have the flu? Absolutely not. And again, it's an invasion of privacy issue. So you do not want to go out telling your other tenants, hey, this tenant got the flu. And in connection with liability, let's talk about entry and access to the units. A lot of the tenants a lot of my clients are asking me, hey, can we get in the unit? What about the tenants that are denying access? You should know that Fair Housing did a seminar telling the tenants to use a reasonable accommodation to prevent landlords from entering the property right now. You don't want to fight it. You don't want to go down the path of getting upset at them. You should write them a letter saying, hey, you've notified me there's repairs. You're denying me access, and that will become important later in an eviction case when they raise habitability. Your letter that they denied you access will go against their habitability claim. So you want to document. I'm going to skip a couple pages because we're running out of time here. But the last question I want to ask is, hey, aren't these laws a taking? Isn't this a violation of my constitutional rights? Can we sue the government? Absolutely. They are a taking. They are a violation of your constitutional rights. As Dan mentioned, Pacific Legal Foundation is already on it. There's several groups right now who are, there's been a couple lawsuits filed actually across the country already. But it is a taking. There are people out there doing it. You just have to realize that these are complicated issues, and they take time to work themselves through. Now, I also hear, what can I do to help? You know what you can do? Dan already brought it up. Please write a check for every unit you own. Write a check for $100 to AOA's legal fund or the PAC, whatever it is that it's called. We will need money to fight these, and we need to fight these. If we don't fight them, we send the message that we're just willing to get, beaten up every single day. And like I said before, it's a power grab. If we don't fight back, you can anticipate that this will keep going in this direction. All right, keys to success. Think long term. Be compassionate and understanding right now. None of your tenants created this situation. Yes, there are cheaters out there. I agree with you 100%. There are people working the system, but there's also a lot of people that aren't. So be compassionate and understanding and try to figure out who's cheating and who's not. Follow the laws. Reach out to your tenants. Keep the lines of communication open. I know many of your tenants aren't responding to you, but continue to reach out. Again, that will look good in court in the future. Hey, I tried. They just wouldn't respond to me. Reach out to your vendors as well and let them know what's going on. And also, finally, on the keys to success, love God and love your neighbor. It's a commandment. And I would suggest to you that be as compassionate as you possibly can right now, and that will go a long way. I'm not saying get steamrolled, but I am saying be compassionate. Pitfalls to avoid: don't overreact, don't fail to follow your laws in your local jurisdiction, and don't act in a manner that's going to be recorded and used against you. All right, we're done. I've finished the slides. I don't know how we're going to do this. Do you want to, are there questions to answer?
We have questions for you.
All right.
Yeah, so what we're doing, the people are now typing in. If you are at home watching, you can type those questions in. Again, it's that blue little chat box that is at the bottom right-hand side of the screen. And go there and you can type in a question. We'll process those through here, and then it'll come to this computer. So go ahead and you can start asking questions. He covered a lot of things. So you may have some specific questions. And so here we go. So thank you so much, by the way. That
you're
was
very
so
welcome.
informative and comprehensive. Really, really appreciate you. And so first question is LA County. You mentioned videotaping to use as evidence. What type of taping, audio, video, is legal and admissible in court?
If the transactions are taking place in public, you can certainly videotape it, and video usually comes with audio, so that's a non-issue. I will caution you: do not audio record people without their knowledge, because there is a specific cause of action that comes. Last time I checked, it was $5,000. If you get caught doing that, you're out $5,000 for that.
Right.
So don't do it without their knowledge, but out in a public space, you can certainly videotape.
Okay, here's a really good question. With the HCI DLA,
Yes.
they had that prohibition on rent increases, but it does say that the maximum adjusted rent of any occupied unit may not be increased unless necessary to obtain a just and reasonable return until 1 year following the termination of the local emergency. Please explain what is a just and reasonable return.
That's really interesting. So that is a program in the city of Los Angeles' housing program under rent control. Just and reasonable return is if you're seeking any sort of profit, you're not going to win that. And I know that sounds cynical and facetious, but it's literally true. I have represented people going through that process, and you would think that, let's say, 10% return would be a just and reasonable profit. But invariably, I have seen the housing board deny any sort of request, even where it was incredibly well documented that the landlord had put a significant amount of money into the property. They weren't making money. The tenants were paying significantly below market rent. We are just in an environment where to believe that the Los Angeles Housing Department is going to allow you to make a just and reasonable profit or return, it would be foolish to believe that. It's not happening, especially right now. So I would not encourage you, especially during this period, I would not encourage you to spend any money or time filing that paperwork. You can do it, and if you think you can be successful at it, fantastic. Please call me and let me know what you did that was different. But I've never seen the board actually issue the request. I've seen them issue significantly lower amounts to bring what was a dilapidated building up to a point where the landlord could actually, start to maintain it. But that was a rare instance. So I'm not hopeful that will work.
Great, and I have a question that you're going to like because it'll help your business, I think. How can I contact you for the 1 hour meeting?
Area code 626-294-0500. 626-294-0500. That's our office number, 626-294-0500. Please be patient. It might take me a little while to get back to you. Like I said, I'm on the phone all day long, and I am reading these ordinances that seem to come out every day, but I will call you back and I'll set up the appointment.
Great, thanks. And here's a good question. This one's specific in West Covina. So the April 6th Judicial Council order stated that if an unlawful detainer had been already filed and the tenant answered, that the court can set a hearing date 60 days from the request. But in West Covina, they will not accept a memorandum to set the trial. So why is that?
So West Covina is part of the Los Angeles Superior Court system. Whether they accept it or not, like I said, the courts are currently closed until at least June 22nd. So if you were already on the docket, yes, they are supposed to be continuing it for 60 days from your original trial date. But they're not right now. As I said before, I've received notices from the court that they're vacating trial dates without resetting it. And I think, and again, this may sound a little bit cynical towards the court system, I think the belief is, I think there's legitimate concern that, hey, we need to open the courts in a safe manner. I accept that. But I also think that there is a degree of belief that, and what are they going to do if we don't set it within 60 days? They're going to file a petition or something? It's going to get them nowhere. And I think that is a mindset. So yes, that is the rule. They are supposed to be setting it. They are not following it. It's a question right now of hurry up and wait. It will reopen. It will reopen. As I said, it's going to be a managed delay. So please be patient. Same thing with writs. You know, I have clients that were literally on the verge of lockout. They had their writ issued, they had sheriff instructions, we had a lockout date, and it's not happening. And they need to be patient. There's nothing that any one attorney or individual can do to rush the courts. They are trying to do this in an organized fashion that, as they say, is safe. And this managed delay is designed to keep the court staff and judges healthy.
Okay, let's say you have a mother and a son living in one unit, and the son is a nuisance. He is harassing other tenants. What can you do about them right now?
So
Can you still evict?
it goes back to that example I gave before. You know, you've got somebody on the property that's harassing people. Let's take a relatively middle of the road example. Let's say the son is running around screaming obscenities at people, you know, just obnoxious, jumping on their cars. Do I believe that the court would issue a summons right now to get rid of that on a nuisance basis? I don't believe so, because the court's thought process goes something like this. If we evict them, they're going to be homeless. Not true, but that's what the tenants' rights have promoted for the last decade, that everybody who gets evicted becomes homeless. And if he's homeless, he's on the streets. And if he's on the streets, he's either exposed to COVID-19 or he's exposing others to COVID-19. So we're not going to put anybody out on the streets right now, unless, like I said, they're burning the building down or they're stabbing people on the property. That rises to that level. So as far as that is concerned, what do you do? What I would encourage you to do is immediately have a law firm write a letter to that tenant and explain to that tenant that the behavior is unacceptable, that while there are moratoriums in place right now, you are reserving your right to move forward on an eviction as soon as these moratoriums lift, and that the behavior won't be tolerated. That's the best you can do right now.
All right, here we go. Rapid fire. We have so many questions.
All right.
City of Thousand Oaks. The tenant has 30 days to show proof of COVID.
Okay.
What if they don't send it?
If the tenant doesn't show proof
Right.
of COVID,
Yeah.
document it. Again, you can't get you're not going to get a summons on it, not at this time, but document it. Let them know that I would write them a letter saying, hey, the City of Thousand Oaks' moratorium requires you to provide this documentation. Your failure to provide the documentation is a sign of bad faith. As soon as the courts open up, I intend to file an eviction against you for this. And if you have any documentation, you know, you're going to have to provide it then. This is not a good way to maintain a good relationship with me. Send me the documentation right now so I can back off.
Okay. So in San Diego, there's a housing provider who's owed money from the tenant from a time before COVID.
Okay.
And so they're curious, how many years do they have to file in small claims court? And then does that time period get extended because of the court's being closed right now?
So they're asking a statute of limitations question, and the way the statute of limitations works is on a oral agreement, an oral contract. There's no written document. You would have 2 years to file that complaint from the date of default. On a written contract, like a rental agreement, you would have 4 years from the date of default to file that complaint. I don't want to get into this strategy. There is something that you could be doing, and possibly I'd have to talk to the person who asked the question. I need to be careful how I say this online. There is something you should be asking yourself and that you should be doing strategically to not only capitalize on the money that's owed right now, but use that as maybe some negotiation, opening the door to a negotiation to get that tenant to vacate based on what they already owe. And that would not involve filing an eviction. So if that individual wants to call my office and talk to me about that, happy to do it.
Great. It's been 7 days since my tenant paid, and they haven't contacted me. What's my next step?
Since they paid?
Yeah, oh, since they haven't paid and it's been 7 days.
Your next step is to, again, reach out in writing in a very professional type of letter. Reach out to them, let them know you haven't paid. Let them know. Send them a copy of Gavin Newsom's executive order that says, hey, you're supposed to provide me with notice. By the way, I'm also asking for documentation. Now, asking for the documentation, I want to be cautious with that. Check your local ordinance. Make sure it does not prohibit you from asking for that documentation before you do that. Assuming it does not, send them the letter, ask for the documentation, notify them that they're required under the executive order to do it. And again, keep doing that. Keep following up. The point is to document, so when you get to court down the line, you can show the judge or the jury, I was incredibly reasonable about this situation, and it casts the tenant into a bad light. It is the tenant was unreasonable, the tenant was uncooperative, I did everything I was supposed to do, and I acted within the law.
Okay, because of the moratorium on evictions, can a landlord file a civil lawsuit for breach of contract against a tenant for not paying rent?
So it goes back to what I was saying before. If your moratorium states that the rent that accrued during COVID is not due for a period of time after the moratorium expires, typically it's 6 months or a year, then no, I would not encourage you to file that right now, because technically what they've done is they've moved the due date from now into the future. I am of the opinion that the obligation still became due on the first of the month when rent was due, typically. But the argument will be made that it may have become due, but it was deferred into a future date. That future date hasn't arrived yet, so I should win this lawsuit. That's the tenant's perspective, and I can see judges agreeing with that. Are you allowed to file a breach of contract action? Absolutely. But there's reasons you might not want to. If you filed a regular breach of contract action, that in Superior Court, that opens you up or exposes you to a cross complaint, which is not permitted in an eviction. So when you're seeking rent in an eviction, the tenant can't file a lawsuit in the eviction against you. It's prohibited by statute. But if you file a breach of contract action, they can sue you right in the same lawsuit. So, and I do believe, I see it all the time. I see tenants file affirmative actions against their landlords on absolutely frivolous claims. So to imagine that it wouldn't happen in a civil suit to seek that rent, I think that'd be a foolish thought. And like I said, I think legally, you're not entitled to that money yet.
Great. Here's the last question that we have. We're on so if there's non-payment of rent, can we use that as an excuse to not fix the rental?
I would not go down that path because the habitability laws are clear. That's a mutual covenant between you two. Their obligation to pay rent is dependent upon the landlord fulfilling their obligation to maintain the unit. Instead, if they're not paying rent, I would absolutely use that time. If the tenant will let you in, I would use this time now to get in, make all of your repairs, get that apartment habitable and up to speed, because when the day comes that you are allowed to sue for this money, you don't want the tenant looking up and using a habitability defense. They're going to do it anyway. But if you go in there and fix the problems now and document it, ideally you'd get your tenant to sign off and say, yes, they fixed the problems, there's no other habitability issues. If they won't sign off, you document it yourself. But no, you cannot use that as an excuse not to fix the unit. You still have to keep that unit habitable assuming they let you in. Now, if they won't let you in a sense, I want to say that's perfect. Because if they raise a habitability defense later, the fourth element of habitability says that the tenant cannot have substantially caused the problem or substantially prevented the landlord from fixing the problem. So if you know about a problem now and a tenant's telling you, you can't come in, it's COVID, great, send them a letter that says, hey, we spoke about this, you notified me, on this date you told me I'm not allowed into your apartment to make that repair. So I'm putting this in writing, I'd like to come in and make this repair. And what you're doing is you're memorializing the conversation. If they sent it in a text, it's even better. If they sent it in an email, great. Their refusal to allow you in will negate your obligation to make that repair, especially right now.
Great. Thank you, Mike, so
you're
much
very
for
welcome.
coming and
Very welcome.
and
Thank you
helping us
guys
so
for,
much. You're
for
just such a
inviting me over to
professional.
talk about it.
So thank
All right.
you very much.
Thank
and
you.
we're going to segue now into the second half of this deal. And I wanted to just introduce the speaker. But before I do, there is so much that's been happening. And what we have a team that works all week long. And at the end of the week, we have a newsletter that we're sending out. You can sign up for that whether you're a member or not. And Chris, I just want to say Chris and her team, amazing what they're putting together. Things are changing so much. You definitely want to subscribe to that. And so our next speaker, he's worked with AOA for years and years, hundreds of our members, and he has helped so many. And he is a professional. He's been in the business since the 1970s. Here we are. That's over 40 years, almost going on 50 years in the business, and he knows his stuff. He emphasized coordination of income, gift, estate, and property taxes as a tool to help property owners better meet non-tax goals for their wealth and families. He, too, is also an apartment owner, and he provides personalized assistance in post-death trust and probate administration. He has incredible ratings. Your speaker today holds the perfect scores for the highest ethical standing and professional excellence from Martindale, Hubble, and other sites, including a perfect 10 out of 10 in Client Choice Awards in estate planning each year from 2014 to 2018. He knows his stuff, so you'll want to listen in. You save yourself some taxes and keep listening here. And he is an avid learner and educator. He's been a professor, an adjunct professor of law at USC, and he speaks at conferences and seminars, and he's a writer as well, contributor to the AOA magazine. And it's my pleasure to introduce to you Ken Ziskin.
Okay, thank you very much. And I'm hoping that I remember to turn my mic on. Yes? Okay, great. We're going to play with the technology a little bit today because we weren't quite able to get my computer to talk to the cameras in the system. So they're able in the back to change slides from time to time, and I hope I'll remember to tell them when to change slides so that you can see some of the images that we put together. I also want to really thank Dan and Jeff and AOA for having me here today. This is my chance not to talk to you about how to make more money. AOA will help you figure out a lot about how to make your apartment buildings work better so you make more money. But I'm going to talk to you about how to keep more money because it doesn't do any good to make it if you can't keep it. So today, let's go to the first slide. And this program is about why your family needs advanced estate planning now, okay? And it turns out that as bad as the pandemic is in terms of people problems and in terms of financial issues for the economy, the pandemic and likely changes in the law really make this the best of times to protect your family from death taxes. Today I'm going to spend a lot of time talking about my crystal ball because planning for the future requires looking into your crystal ball because for one thing we can really be certain of is that tomorrow is going to be different from today. We may not know the ways in which it'll be different, but at least we can try and make some predictions about that. When I do this, the IRS says I should make sure that you know that I'm not giving you advice that you can rely on if you wind up in tax court or in trouble with an auditor. For that, you need advice from an attorney that you have specifically retained who's dealing with your particular situation instead of generalities. Okay? And nothing can substitute for advice from a qualified attorney who knows the stuff in this area. I'm also going to give you some bad news about what I think is coming. Okay? And please, don't confuse the messenger with the message. And unfortunately, there's really not enough time for me to tell you about all the strategies that we can use to help protect your family's wealth. But I can help you figure out how to deal with some of the likely futures and at least which futures are really threatening to you. If you want to know more, you can contact me for any one of a number of things. I'm going to talk to you later about my estate tax exposure ray, which gives you a chance to predict what your estate tax risks are with different assumptions and to change the assumptions. Kind of a fun what-if tool. I can also talk to you about how to explore solutions or just discuss your potential death tax or estate planning situation with you. And I am going to try and do a small webinar to review selected strategies. So you can either give me a call, 818-988-0949, or you can email me at kenziskin@gmail.com. And if they were following along back there in the tech area, I'm on slide 4. Yes? That thumbs up, because I forget. I'm used to being able to click the clicker and move the slides, and I'm not so good at telling them when to change slides. Okay, let's go to slide 5. I think these are tough times, but even in tough times, if we look back, we can find some quotes that are kind of encouraging. I kind of start off with Charles Dickens from A Tale of Two Cities. It was the best of times, it was the worst of times, it was the season of darkness, it was the spring of hope. I'm going to give you a little bit of hope on the tax side, even though I'm going to warn you about some coming darkness. And in 1960, John F. Kennedy said, in Chinese, the word crisis is composed of 2 characters, one representing danger, and we all know there's a lot of danger out there, but the other opportunity. Opportunity is where I want to focus most of my time if I get a chance to help you. And my favorite saying that I always tell my kids whenever they see something that they don't like, when life gives you lemonades, make lemonade. Okay? If we can move to slide 6. Okay? Fortunately, if you act in time, you really can make lemonade for your family's wealth. And if you don't, a death and gift tax tsunami is coming to crush the wealth that you've built with your property and with your efforts and with all the years when you probably deferred a lot of gratification to build wealth for you and your family. Go to slide 8. We've had some good news in the last few years. In 1918, Trump had the Tax Cut and Jobs Act come into effect, and it doubled the death tax exemption. So right now, if you've got an estate with over $11 million, you don't have to worry about estate taxes, provided you die today, okay? But this exemption, unfortunately, was a use it or lose it exemption, okay? If the laws do not change, the death tax exemption automatically sunsets, gets cut in half on January 1, 2026. And I'm hoping the vast bulk of you, or maybe all of you, are still going to be around in 2026. So estate tax problems are going to become a lot more difficult at that point. Okay? Sunset is really a time bomb that's going to make a lot of people who thought they didn't have estate tax problems discover that they have them. And that, for slide 10, is before the virus deficit struck, okay? And the virus deficit resulted in trillions of dollars of emergency spending. I kind of wanted to see what trillions look like, and I sat and wrote it out. It's a 1 followed by 12 zeros. I mean, that is just too much money to imagine. I'm old enough to remember when $1 million sounded like a lot of money. And unfortunately, trillions more are coming because they're going to keep throwing money at the problems, okay? On top of that, tax revenues declined, okay, significantly. You got to pay your income taxes later. You could file returns later. Lots of tax revenues related to economic activity was slowed down. Deficits are going to be huge. And not just at the federal level. They're going to be big at California level as well for health care costs, unemployment, reduced revenues from taxes. What do you think legislators will do when the recovery begins? Or maybe even sooner when they start worrying about how many zeros have been added to the deficit. I think they're going to have a lot of pressure to raise taxes on somebody. And it's a lot easier to raise taxes on the wealthy than on everybody else. And while I don't have any clients that think they're wealthy, whether they've got $1 million of property or $50 million of property or $200 million of property, they think you're wealthy if you've got any rental property at all, probably, okay? And I think the pressure to raise taxes is going to be irresistible. Now, the Democrats already told us what they want to do to the wealthy, and they've been telling it to us for very many years. In 2016, on slide 13, Obama had a proposal. Increase the federal capital gains tax to 28%. He wasn't talking about adding the net investment income tax on, but later Trump did that. And while the California rate can be as high as 13.3% for some people, when you combine it all, you can be looking at almost 50%, including depreciation recapture, just on capital gains, okay? Obama wanted to eliminate the step-up in basis. Step-up in basis is this wonderful thing that says if you have property in your estate when you die, it gets a brand new income tax basis. And then your kids or your heirs can sell the property and pay no capital gains tax. Or if they don't sell it, they can start getting a lot more depreciation than you did and shelter a lot more of the rental income. Great deal. Obama wants to get rid of it, okay? He wanted to also increase the estate and gift tax rate to 45% from 40%. Sounds pretty bad, but wait till you see, things get worse. Let's go to slide 14. Bernie Sanders and a member of the House of Representatives, Gomez, came up with their proposal in 2019. They call it for the 99.8% Act, okay? Basically, they want 99.8% of the people in the country to think this won't hurt them at all. It's just that top 0.2% that get hurt. Not sure the numbers are quite right, but they're going to make a big deal out of that. And certainly 97 or 98 or 99% of the country won't have to worry about this tax bill hitting them directly. Bernie's pitch, and not mine, is that the fairest way to reduce wealth inequality, to invest in the disappearing middle class, and preserve our democracy is to enact a progressive estate tax on the inherited wealth of multimillionaires and billionaires. Not leaving it just to billionaires, multimillionaires. That only requires having $2 billion, although most of Bernie's stuff doesn't hit you until you've got a little bit more than that. Let's go to slide 15, okay? So, specific things he would do. Reduce the death and gift tax exemption to $3.5 million per person. Not about the approximately $6 million that we get with Sunset, not to $5 million, but to $3.5 million a person. He would increase rates. You can see from 45% on up to 10 million to 50% on the next one, next tranche, 55% if you've got over 50 million. Most of you probably don't have to worry about that one yet. And 70% above $1 billion. I don't have any clients with that much money, so I'm not too worried about that one hitting my clientele. He's going to end generation skipping exemptions beyond 50 years. And this is what has allowed you to build wealth to take care of your children and then your grandchildren and your great-grandchildren and generations to come. And he's going to say, nope, that's only going to work for 50 years, and then that property is going to be back in the death tax system. He even wants to hit some little things and limit annual exclusion gifts. Today, every person can give $15,000 to each of as many people as you want to. Okay? So a couple with 2 children and 4 grandchildren can, for now, give up to $180,000 a year without it impacting at all on their lifetime estate tax exemptions. Bernie's proposal, only $10,000 to one person in any given year, and you only get a total of $20,000 of annual exclusions. So it'll really limit the ability to get wealth out as you get older without worrying about the system. Slide 16. Okay? In addition to that, they're going to make big limits on our valuable estate planning tools. And these are the ways we're able to, frankly, manipulate the law to use your exemptions more effectively. Less tools mean that it will be much harder to plan well. They're going to limit a strategy we call a grantor retained annuity trust, which actually can be a great strategy for both getting assets out of your estate and avoiding any property tax reassessment. They're going to tax, if ever you do a grantor trust of any kind, if it allows for distributions of money to your heirs, and it actually does distribute money during your lifetime, or else they'll tax everything that was in that grantor trust when you die. Today, we can set up those kinds of trusts and not have the proceeds that are distributed to your beneficiaries taxed, whether they're distributed while you're alive or after you're gone. And one of the beauties of grantor trusts is that you, the donor, gets to pay the income taxes on what the trust earns, and it's not treated as a gift. It's a great way to enhance the amount of money that you transfer for subsequent generations because they get the benefit of tax-free income, and your transfer of that tax benefit is not treated as a gift today. They're going to end that. And they're going to limit our ability to get discounts with partnerships, LLCs, and other companies. Discounts are real, but discounts, when they're structured right, help you make your gifts work better without having to decrease the real value that it will have for your family. Now, amazingly, on slide 17, Biden has a very mild proposal, maybe because he came out with it fairly early. Unfortunately, he would raise the top income tax rate to 39.6%. He would tax capital gains at ordinary rates, but only if income is more than $1 million. But you don't have to sell a very expensive apartment building to necessarily have more than $1 million these days. And he would eliminate the step up in basis at death, which is the way you get to reset your income tax basis and prevent your heirs from having to pay capital gains taxes or give your heirs the ability to get more depreciation. But these mild proposals were all made long before the virus deficit started to explode. My guess is if Biden gets into office and he has a Democratic Congress, we're going to see proposals much closer to what the Sanders-Gomez proposals are, and that's too bad if you've accumulated just a little bit of wealth. What if California adds a death tax? There are a lot of states that have death taxes. Our budget deficit was projected a little less than 2 weeks ago at $54 billion, okay? Who are they going to tax to make up for that? The poor the middle class, or the people that they think are rich? In California last year, we had a proposal to bring on a death tax, much like many of the other Western states have. It didn't pass, but we weren't facing these budget deficits. We still had surpluses. In Washington, for example, the state of Washington, there is a 14 to 20% death tax with a $2.2 million exemption. That winds up being on top of the federal taxes and can really hit hard. I think the odds are that during the lives of most of you, California is going to have a death tax. We're just going to have to see how bad it is. So maybe you don't all have to worry about death tax risks, but on slide 19, we're going to talk a little bit about what you should worry about and who should worry about it. Any single person with more than $5 million today is in a position where sunset is probably going to leave them with a death tax exposure. Any married couple with more than $1 million today is probably in a position where sunset will leave them with a death tax exposure. And in both cases, this is not counting any big gifts that you make during your lifetime. And if Gomez-Sanders passes, you really have to worry at much lower levels of net worth, probably around $3 million for a single person or $6 million for a married couple, maybe even less if you have a longer life expectancy and expect your wealth to grow more. And of course, you have to worry more if you have higher net worths. If you want to project your risk, I do something called an estate tax exposure X-ray on an Excel slide, which I can give you a copy of, and you can do your own projections, or you can talk to me and I can do projections for you. Here's a kind of simplified example of how that works. This was for a couple in their 70s, okay? They estimated they had about a 15-year life expectancy. They thought their property would grow at about 4.5% a year, starting off with a $15 million estate. The death tax for them, they've got a big enough exemption that they have almost no problem if sunset doesn't happen. The problem is sunset is going to happen only about 5 years from now, okay? And without sunset, and with sunset, excuse me, they're looking at almost $6 million of death tax exposure at life expectancy, more if they live longer or their assets grow faster, and almost over $9 million of exposure if we see the worst case, which is the federal rates going up to 55%, California bringing in a 20% rate, and I'm assuming the California rates will be deductible for federal purposes, which is not a guarantee. This is a big deal, okay? And let's see if I can get this right. Okay. Let's go to slide 21. A couple more rough projections. For a married couple in their early 70s, a $10 million net worth today, they're looking at between about $2.4 and $4 million of death tax. A single person in their early 70s with a $7 million net worth is still projecting between about $3 and $5 million of death taxes. And at that level, if you got a few kids, that is a big hit and is really going to reduce what you can leave to your heirs. Single person, early 70s, $5 million net worth, he or she is still looking at probably $1.2 to $2.1 million of death taxes. Let's go to slide 22. The good thing is, death taxes have almost always been voluntary. If you fail to do good and timely planning, you volunteer, not to pay them yourselves, but to have your kids and grandkids pay them. But the reality is, if you do good planning, if you do it on a timely basis, modern planning can protect millions more for your family. Even with very large estates, in fact, we can do planning for most estates and protect 20, 30, 40, 50, maybe even 100 million if you've got a few more years of life expectancy left. Go to slide 23. The most effective time to do death tax planning depends really on 4 factors. First, you want to do it before exemptions drop or planning tools get limited. My fear is that we are going to see exemptions drop and planning tools get limited no later than when the Democrats have some power in Congress and have the White House. And maybe that'll be in 2020, maybe it'll be in 2024 election, maybe it'll be later, but sooner or later that pendulum will swing. It's best to do this planning when your life expectancy is the longest. And the reality is, every day your life expectancy gets a little bit shorter as you get closer to your appointed time. It works best when values are depressed a little bit. And when I listened to Mike about all the rental restrictions and the restrictions on your ability to enforce your legal rights against your tenants, I can understand why values ought to be a little depressed until we get past these legal restrictions, or the Pacific Legal Foundation or somebody else gets some of these restrictions declared unconstitutional. And finally, this planning is more effective when Treasury interest rates that are used to measure gifts are low. So here's a little Venn diagram that shows how it all gets put together. In slide, and I remember this is slide 24, before exemptions drop or your tools are limited, that's part of it. When values are depressed, that's part of it. When life expectancy is the longest, and it's longer today than it will be next year, and when Treasury rates are low, all those factors have come together, giving us a sweet spot for planning that will probably never exist again. Now, one reason clients don't do good death tax planning is they're afraid that they have to give money irrevocably, and they might run out of money and not be able to get it back for their spending. But the reality is, good modern estate tax planning gives you an ability to access the money in your planning if you need to, and still keep it outside of your estate. We want you to be poor for estate tax purposes, and frankly, I want you to be poor if somebody decides to sue you, so you're poor for liability protection purposes, but I always want you to be able to get as much money to spend as you might want or need to spend for your lifestyle and to take care of yourself. But there's more good news about the way advanced planning can work these days. I call these planning bonuses, okay? One of them is that it gives you very powerful liability protection, much more protection than you can get with a limited liability company or a family limited partnership. It enables you to pass wealth from generation to generation. I'm lucky enough, my kids do okay. I'm not too worried about them needing to spend my wealth. My grandchildren, I think the world's going to be tough for them. I want money to be able to be there for them and for my great-grandchildren. I have no idea what the world will be like when it gets there. We can do that with good planning now if we do it before the laws change. And it's possible that good planning will give you current income tax benefits. We have ways to get around some of the limits on itemized deductions, okay? And one of those limits is you don't get to deduct your California state taxes much anymore if they're over $10,000. And we have a strategy that I've written about before called the Accelerated Step-Up Strategy, or ACES. And it allows you to increase your income tax basis without dying. And all of these are really bonuses that come with the kind of planning that we do to help protect you against death taxes. Go to slide 27. Now, even if we can give you access, a lot of clients say, maybe I'll wait. I'll do this after the new laws pass and I see what happens. Unfortunately, we don't know what the effective date of new laws will be, and that makes waiting very dangerous. Okay? Will it be the date the bill is introduced, or the date of enactment, or maybe next year? Sometimes we get next year. are you willing to bet millions of dollars of your family wealth that they'll cooperate and set an effective date that's far enough in advance that you'll have time to do good planning? I think that's a very difficult prospect to count on. The choice on this really comes down to something that you can do. You can do nothing now and volunteer your family to pay millions in death taxes. Won't cost you, you'll be gone, okay? Or you can plan on a timely basis and you can save them millions of dollars so that you can protect generations. If we look at slide 29, I think doing advanced planning is like buying fire insurance. Sure, you all have kept fire insurance and casualty insurance on your buildings for years, and most of you have probably never had a significant claim. But it's worth paying that money, okay? It simply would not work, however, if you try to buy the policy after the fire. I think the fire is coming for you because they're going to raise death taxes and they're going to make it really difficult for you to buy the kind of policy that protects you against it by doing good planning. So that's why I think if you have any kind of significant wealth, you can decide how significant that may be depending on what you think they're going to do to reduce exemptions. But if you do, the time to plan is really now. My Family Wealth Strategies motto, if you've read any of my articles or you've been to any seminars, you've heard me say this over and over again, and it means even more today. If you fail to plan well now, plan to fail. Don't procrastinate. You know, if nothing else, you always have the risk of getting hit by a bus, but now you've got bigger risks because there is a big bus coming after your wealth from the legislature in Sacramento and at some point from Washington. So, what should you do? You should find an estate planning attorney you feel comfortable with, okay? It should be someone who has the right experience dealing with advanced strategies to help you, and someone who understands and focuses on advanced planning strategies and how they impact on rental property. It's very different than planning for a doctor's medical practice or for somebody who has all their money in IRAs or stock accounts. And someone who will spend enough time with you so that you can understand the potential strategies and can make the right planning choices. Go to slide 32, which is where I'm going to finish. If you want to learn more, if you want to get a copy of the death tax exposure ray so you can project your own risk and run through a few what-if calculations on your own, if you want to get invited to a small group webinar where I will go over advanced strategies, or if you want to consult with me so that I'll use your situation as a case study, give me a call. Phone number's on the screen, I think, 818-988-0949. Or send me an email to kenziskin@gmail.com. I would love to talk to you. You don't get my young associate or a paralegal. You get to talk to me occasionally. My wife answers the phone. She's much nicer than I am, so you'll enjoy talking to her. But if you really want technical stuff, you're stuck with me. Okay, and now I'm going to hope maybe we got a couple of questions and that I'll know the answers, and we can probably go off the slides.
Great. Right now, thank you so much. Right now, we don't have any questions. If you do have a question, this is the time that you could submit that, where you, in that little blue help box, you can submit your question there. And if not, we'll go ahead and wrap up. And you did write an article, I believe it was in the March or April magazine.
Yeah, I write frequently, and
Yeah.
I always get people who call me and say, I read your article, and I have to ask them when, because a lot of your members read their articles, read the magazine in chunks, so they'll be calling me about articles that were written a year ago or 2 years ago. So I don't remember. I know when I write them, but I don't remember when they come in.
Right,
but we did write about the risk of the death tax getting
Right.
worse. And that was before we knew about the COVID crisis. And I think the COVID crisis makes the risk just a lot greater than it was beforehand because the deficits are so much huger.
Right. Yeah, I think it was the April. I
Yeah.
think it was April. Could you repeat your email address?
Yeah. The email address, if you want to write to me, and I will respond to you, is Ken Ziskin, KenZiskin, @gmail.com. It's nice and simple. You'll get me. Probably I'll wind up giving you a call to talk to you. I love talking to clients. I wish that was the only thing I ever did in my day. That's the most fun part of the practice.
Great. And then your address, and then what will they get from you?
If you want a copy of the estate tax exposure rate that lets you project your own estate tax risk with your own what-if assumptions, ask for that. I'll send it to you in Excel format. If you use Excel, you'll be able to do the projections yourself. If you're not an Excel user, you can call me and talk through your your assumptions, and I can actually run the projection very quickly for you.
Great. Here's a good question. How do I get an inter vivos basis step up?
Okay, an inter vivos
Vivos,
basis
yeah.
step up. So how do you get a step up in basis while you're still alive? And there is a strategy that became popular a few years ago where we would give someone older than you or with a shorter life expectancy a power of appointment over your property. And we give it to them in a way that makes it almost impossible for them to use it. Might be your mother or your aunt or your uncle. And just because they have that power, property will be deemed to be in their estate when they die. And when they die, your property will get the step up in basis. This has to be structured very carefully to make sure that we keep the money spendable by you during your lifetime, that the person who has that power won't really be able to give it away to people outside your family or maybe to anybody other than you. And we can use it in a way where it won't cause an estate tax at the time they die. And we can do all that, and that has become a fabulous strategy for people who have an appropriate person to be the power holder.
Okay. Here's the next question. Thank you for writing in. We have a couple questions here now. I own a property in a living trust. My homeowner's insurance policy is in my name. My insurance broker suggests adding the living trust as an additional insured. Do I need to do this? Why or why not?
Your insurance broker is absolutely right. If the owner is your living trust, it should either be the insured or it should be an additional insured. Probably you want the named insureds to include both you or whoever is the trustee of the trust and the trust itself. And my understanding from talking to insurance brokers is that you can do that without having to pay any additional premium for it.
Okay, in the next question here, these are great questions. Keep them coming. If I have a grant or trust and the law changes, would the trust not be worth having done?
The question is, if you have a grant or trust and the law changes, will that take away the benefits? We can't be sure what will happen when the law changes. Historically, when you've had irrevocable trusts and the law has changed, the law has said it applies going forward, but they haven't made it apply to irrevocable trusts that were done before the effective date, which is usually the date the law is enacted and signed by the president. I can't guarantee you that it would be impossible for them to go back and change it, but so far the law has not done that. So many of the sections in the Internal Revenue Code about estate tax law will have a very brief rule, which is easy to read and understand. And then there will be pages of rules as to what happens if you had done your trust before 1941 and what happened if you did it after 1941 but before 1956, and so on, as they go through all the different effective dates. But in the past, they have always understood that if you did irrevocable trust planning, they shouldn't upset it with new laws.
Okay, this is another good question. At what level of wealth do you think someone should plan and have this come and talk to you? If they have $800,000, is it worth their time, or do they? Yeah, what would that threshold be?
Yeah, for 800,000, I don't think you're going to face any death tax exposure, and if you do, probably it's so far in the future that it's not really worth trying to plan for today. I think for single people, certainly if you've got a net worth over 5 million, maybe if you have a net worth over 2 or 3 million, it's worth thinking about whether you can get some of your wealth outside your estate. For a married couple, I think it becomes worthwhile really thinking seriously about this if you're much over $7 million, certainly if you're over $10 million. And again, if you're a married couple in your 40s and you've got a $6 or $7 million net worth, your life expectancy is long enough. You're probably going to wind up ultimately with a net worth in the 18 to 20 or $1 million range or higher. And that means you're going to be in a range where there will be estate tax and death tax exposure. And it's worth at least thinking about whether you should plan today. A big part of what I think is worth doing for clients and potential clients is helping them project out what their risk is. And then after you see what the risk is, you can decide whether it's worth taking steps to plan now or whether you want to wait and take steps to plan later.
And a question: will the slides be available some way?
Will the slides be available some way? Usually I don't give out the slides. My wife is really nervous that somehow if I give out my slides, some other lawyer is going to get them and crib from them. So probably she's going to tell me when I get home that I better have not promised anybody the slides. And for domestic tranquility, I am therefore not promising the slides to anyone.
Okay. Get it now, right?
Yeah.
Okay, do you employ foundations as a method of estate planning? And if so, how do you do this?
Okay, how do you do it? How do you do it is come in and talk. But yes, doing foundations or other charitable planning can be really great if you're charitably motivated. Sometimes the benefits of charity can be so great, income tax and estate tax savings, that it's almost free to give money away to charity. And that kind of planning works really well for almost anyone. But in general, charitable planning works best if you've got a little charitable motivation and you're willing to let the government pick up 75 or 80% of the bill and do the rest by giving benefits to your family. And doing charitable planning, whether it's through foundations or donor advised funds, or you just want to give your money to Pacific Legal Foundation so that they can support renters' rights, whichever way you want to do it can work really well.
Is there a cost for the small group webinar?
The small group webinar will not have a cost. I'm going to do that so I can try and tell a lot of people a little bit more about strategies, and I will hope that a few people find that interesting enough that they're able to go forward and decide to do good planning. Whether they do that with me or with somebody else, I'll feel like I've done something good.
So, and some of our members are out maybe showing a place right now or fixing some plumbing, and they're going to see this video later. And so a month from now, let's say or a week or a couple weeks from now, let's say they see the video, are you still going to be accessible to them?
Yeah, I hope so. I mean, I'd like to think that I'll be so busy that I'll have to tell you I can't call you back right away. But the reality is we try and get back to everybody the day they call. And I'm looking forward to doing this for clients and apartment owners at least until the law changes. Don't know when the law will change, and that's going to be scary, but for as long as possible, I want to keep dealing with apartment owners. The smartest thing I ever did in my practice was the day I called Dan and said, I'd like to start working with apartment owners and doing estate planning for them. It's been the best thing for my practice. I've gotten to meet a lot of really nice people, and I'm thrilled that I did it.
Okay, thank you. The questions keep coming in. We have a couple more here. The step-up process for power over. Have you seen this process be effective after the person whom the estate was placed in is deceased?
No. Almost the step-up planning has to be done before whoever's estate we're going to use, before they die, okay? And so we have to think in advance. If you come to me and your grandmother died last week, I can't do anything to change how her estate is going to work. It's baked into stone. It may turn out that you've done something that put property in her estate and gets a step up in basis, but it's too late for me to do anything about it.
Okay, here's another one. Is it suggested to form a different entity name for each property to protect all of your other assets in case of a lawsuit to one asset?
For liability protection, there are advantages to having different entities for different properties. Unfortunately, there are costs that come with that, particularly some property tax costs. So it's not a question that has a simple answer. There are advantages, there are disadvantages. You have to get somebody who understands both the advantages and disadvantages to go through them with you for your particular situation. And then the reality is, on these kinds of issues where there are pluses and minuses, you don't want me to make the decision. You want me to give you enough advice and educate you well enough so that you can make a good decision. And that's the way I think good estate planning and good planning overall should be done.
All right, we have a question coming in. Here it is. Isn't the 2020 exclusion for married couples 22.16 million, not 11 million for a single? Oh, yeah. I'll just ask this one. Isn't the 2020 exclusion for married couples 23.16 million?
23.16. Not in the 22s. It's 23.16 this year. Next year, if nothing changes, it will probably go up a little bit. It's supposed to go up with inflation. I think they do the inflation calculation around September of the year. This year they might decide that there wasn't any inflation. So it may stay the same or even go down a little bit as they adjust it. But in general, it goes up each year with a little bit of inflation. The way they calculate inflation, if you and I think that spending inflation has really been 2 or 3%, they'll think inflation for estate tax purposes was only 1 or 1.5.
Okay, and then for singles, is it 11 million?
For singles, it's 11.58 million.
Okay, there we go. There's the precise
Today.
number.
Yeah.
Thank you. And could you clarify if you work with clients for estate planning and creating trusts?
Yes. Yeah. Most of my clients don't need advanced planning, or certainly weren't worried about advanced planning until we started looking at how the law might change. And for them, we do really good living trusts. And a good living trust should have good tax impacts. And that doesn't just mean estate tax impacts. It also means income taxes and property tax impacts. But just as important, it has to work well on a non-tax basis for your family. My experience is that almost every family has non-tax issues that have to be dealt with, and you should work with someone who will spend the time helping you articulate your non-tax concerns and then helping you show how to deal with them, even if your trust and your situation doesn't require any sophisticated tax planning.
Okay, here's a question on that 706 form. I have been able to discount for conversion to cash in short order and for closing costs to help shrink an estate. Do you feel those will be available in the appraisal process?
Discounts are probably still available in most cases. How much discount you get depends on the structure of your portfolio, but some discounting is available and can save taxes in almost every estate, or at least you get to deduct some expenses. A lot of discounting will go away if something like the Sanders-Gomez proposal passes. Don't know if that's going to happen, and I don't know when, if it happens. It will be there. And the good thing to know is that we estate planners tend to be pretty imaginative. So when they close a loophole, we usually can find some other loophole that gets some of the benefit back. If they've done a good job closing the loophole, we can't get very much back, but we're always out there looking for imaginative ways to save taxes for our clients.
And we have a viewer right now. They made a trust 8 years ago, and they're wondering if they can come to you for a consultation.
Yeah. The vast bulk of my practice, as I said, is working with apartment owners. And I think apartment owners really show that they think ahead. Most of them don't spend every penny they can get, and they plan for the future. So almost all my clients already have living trusts. And they come to me and we review their living trust, talk about how well it works for today's laws and for the issues that concern them today. Sometimes I tell people, I think your trust does a great job and there's nothing else you could do. Most of the time, we talk about things that can be improved. And if the improvements are significant enough, a big part of my practice is restating or redrafting people's existing living trusts rather than drafting somebody's first trust.
If there's not a lot to protect the owner, should we sell the apartment building? Maybe what they're asking. I think you know what they're asking.
I think they're asking, if times are tough, should I just sell and pay my capital gains taxes today? And maybe, but the capital gains tax hit can be really big if you've owned property for a long time. So it's worth thinking about other ways to protect yourself from liabilities, protect the property so it won't get an estate tax, or protect it and make sure you can get a step up in basis if it's still available. The big problem that I see is the step up in basis is really a good deal for owners. However, I think the trend around the world, and certainly the trend in democratic circles, is to say that the step up in basis is too much of a giveaway. And I think the step up in basis probably won't last as long as I'm alive, and a lot of you are going to be alive longer than I am, so your chances of it lasting are worse.
Okay, what do you charge for a living trust?
Okay, that's a good question.
It's a really good question.
I spend a lot of time with my clients, okay, figuring out what they want to do, figuring out their situation, and educating them about their options so that they can make the big decisions instead of me. So I'm not the cheapest guy in town. For a living trust for a single person, normally I charge $5,000. For a married couple, normally it's $6,000. If you have a real simple situation, occasionally I've charged a little bit less, but usually not, because I think what looks like a simple situation in the beginning often winds up being complicated in the end. Some people have a sufficiently complex situation that I might charge more, but it's a very rare thing.
Yeah, it's very interesting. There's a return on the investment. Like, they're putting $5,000 down. They're paying that up front, but you're saving them millions. Like, on average, how much are you saving them? That's a question.
My target when I do advanced planning, I want clients to feel pretty comfortable. They're probably going to save at least $100 for every dollar they spend on the planning. Okay, and I'm not sure when you're going to save that $100, but I'm pretty sure the present value of $100, even at the end of your life expectancy, will be pretty good today. Okay, when I do basic living trust planning, we often get savings that good just by modernizing the way the trust will work for tax purposes. But sometimes when we redo somebody's living trust, we're not doing it to get necessarily better tax treatment. We're doing it to get better non-tax treatment. And I don't think it does a lot of good to save taxes and have a trust that for non-tax purposes doesn't work for your family.
All right. Well, thank you so much, Ken.
Okay. I really enjoyed being here. It's always great to be at AOA. The only thing I miss is I wish there were a couple of hundred of you out there that I could talk to directly.
Thank you, Ken. Appreciate you being here today, and appreciate all of you that are out there listening in on this webinar. We'll be having another one in a couple of weeks, so you'll want to watch your email for announcement for that. And also we want to thank those of you who sent in donations to the Political Action Committee. I think you're demonstrating that you think your property is worth quite a bit to protect and is worth protecting. And if you would like, those of you who would like to make additional donations or a donation, you haven't done that yet, you can send a check in to 6445 Sepulveda Boulevard, Van Nuys, 91411. That's 6445 Sepulveda Boulevard, Van Nuys, 91411. Also, you can go online at aoausa.com/PAC. That's political, it stands for Political Action Committee. So it's aoausa.com/PAC, and you can make a donation on the website at that location. Also, there's an individual attorney today that went into court to sue for this to stop the eviction, and hopefully in a couple of weeks we'll have some kind of an update on that lawsuit, an update also on the lawsuit that we're supporting with the Pacific Legal Foundation. Those things are important. They're important to you. If we could get rid of these things so that we can evict people, I think a lot will just start paying their rent, and you won't have to go through an eviction, just knowing that's the case. Be sure also go on the AOA website. If you'll go down just a little bit, aoausa.com, go down just a little bit, and to your left there's a petition. We've got 80-some thousand signatures on that petition. I'd like to get about 15,000 more. So those of you who have not signed that petition, please go to our website, sign that, send it on to a politician. Let him know what's going on. Let him see that. Also, your friends, ask your friends to sign. You can ask tenants to sign that too. Also on the AOA magazine, this month in the AOA magazine, we have, we have a petition in there to mail in to the governor. You'll want to mail that in. In other words, we'll hit them with the internet signatures, and we'll hit them with your individuals. Go to your magazine and just tear out the 2 pages. There's 2 pages now, not just one. 2 pages to tear out. Sign the petition. Your tenants should also sign it, simply because it's asking to give them money so they can pay their rent. And so you'll want to do that also. Thank you all very much for being with us today. We hope to see you again in a couple of weeks. Thank you.